The Federal and SR Public Welfare Trust present the Pudukkottai Marathon 2025. This event is co-presented by Rupee Apex Group of Companies on Sunday, August 3.
Welcome to the latest episode of the Federal's Worldly Wise, a video program where we dissect the latest in international news. Late last week, China started the construction of the world's largest hydropower dam in Tibet across the Yarlung Zangbo river that flows into India and Bangladesh as the mighty Brahmaputra. The dam is causing concern as there are fears it will affect a large number of people in India and Bangladesh. To decode what precisely the issue is, how the dam is going to affect India and Bangladesh, if at all, and whether international laws on sharing of river water apply to this issue, we have with us senior Supreme Court lawyer Mohan Katarki, who is an expert on the subject of sharing of river waters. Mr. Katarki has appeared in several complex interstate river water disputes over 4 decades, defending various states. He has written extensively on the subject, both at the national and international levels. Welcome to the program, Mr. Katarki.
Thank you, Dakshinamurthy. My pleasure.
In the context of China's new dam construction in Tibet that is expected to impact the flow of water downstream in the Brahmaputra river, what are the rules of international law which govern the rights of upstream and downstream states to utilize the waters that flow through more than one country?
Yeah, Dakshinamurthy,
Yeah.
to understand the international water law, which is not really that complex, in fact, I would say it is a part of the larger international law, it is necessary to have a brief idea about the basin factors because the law is applied to the basin, which is always complex. In fact, each basin is called sui generis, means it has its own characteristics. Now let us look at the first, what is this Brahmaputra basin? The basin is a catchment which consists of main river and tributaries, rise in the mountain, flow down into the plains, and finally they enter the deltaic portion, that's called where the river splits, and finally the water merges into the sea. This is the typical structure of any river basin. Historically, as a nature's gift, people in the downstream, the deltaic region, utilize the water. This is the case with the Brahmaputra, Ganges Delta, Mekong Delta, Indus Delta, Nile Delta, or Mesopotamia Delta. Everywhere, the situation is same. Now look to the Brahmaputra basin. The river rises in the China, that is Tibet part of China. It runs for a long about 1,625 kilometers, takes a turn, enters India, and runs about 918 kilometers, then enters Bangladesh, where really the delta starts, and rather the delta of Brahmaputra and Ganges merge together, and it runs about 337 kilometers broadly. This is how the physiography of the river is. Now the question arises, what is the status of this international river where the water flows from one country to another country, that is upstream to downstream? In this case of Brahmaputra, there are 3 riparian states. One is China, being in possession of Tibet, India, and Bangladesh. We are also Bhutan to some extent because some tributary rise in Bhutan. But at the moment, we are really concerned with India and China, which relates to the dispute which we are going to discuss. Now, if you look to the basin, as I said, India is the downstream and China is the upstream. When an upstream state takes up a project, downstream state bound to feel the impact of it in the form of reduction of flows quantitatively or in the change of pattern of the flows, depending upon the nature of the project which upstream state takes up. Now, how to resolve these conflicts has been the subject of international law for long. Initially, when high dam technology came into picture in the middle of the 19th century, the question arose, what are the obligations of the upstream state when it decides to build a dam and reduces the flow, and which invariably affects the downstream where the delta portion is located, where historically water was used as by natural means. The same case with any of the delta, as I said. United States of America, when the dispute arose between US and Mexico with regard to the Rio Grande, the Attorney General of US said, I'm a sovereign state, and as an incident of sovereignty, I have right to control the entire my territory, which includes the water that is generated in my territory. I owe no obligation to the downstream state, so I do what I like. If I give to the downstream state, it is my grace, nothing more. Or in other words, he said, the downstream state cannot complain injury because it has no rights. This appeared very attractive. But the same America has to learn within 2 decades, that is by 1910, that being a lower riparian to the various rivers flowing from Canada, it cannot really speak of Harmon doctrine. So then it started really thinking of what are the rights of a downstream state as a downstream state to various rivers coming from Canada. So based upon that, an agreement was entered in 1910, and there America conceded that it is not the Harmon doctrine, it is the doctrine of equitable sharing which applies between two riparian states. Simultaneously, also in other parts of the world, there was a claim by the downstream state, which is opposite of the Harmon doctrine. They said that river has to flow in the state of nature, and that is called riparian theory or natural flow theory. If this theory applied, the upstream state cannot do anything. It has to just look at the river flowing down, and the downstream state, by applying the natural flow theory, was entitled to all the water. So this theory was also considered to be an extreme, as Harmon was considered extreme. As a reconciliation of this, the doctrine of equitable apportionment arose, started with, you can say, US and Canada case, and thereafter several federal disputes arose in America where this doctrine was applied, and subsequently International Court of Justice in older case said community of interest theory. Then later in the case of Gapsico and recent Pulp case, the International Court of Justice has also said the ruling doctrine or a customary rule of international law is equitable sharing of the water, where all the states have equal rights, but the extent of right to be decided based upon the equitable factors. So that's how broadly the law stands. As within this broad contours of law, four principles are emerged. One is each state has an equitable share. Fine. Secondly, no state shall conduct itself in such a manner that it will cause harm to the other state. Right? Now, there is some controversy. What do you mean by harm? is it a harm to the existing utilization which deltas and downstreams have been using historically, or it is to the legal right? Then there is a recent origin of a principle that all the states are obliged to utilize water in such a manner that they will not cause any damage to the environment. And of recent, a new principle has also emerged. Whenever a project is taken up by the extreme, which it is entitled to take usually unilaterally, there's no difficulty, as the Lake Lano case decided long back between Spain and France. But it must conduct transboundary impact assessment to satisfy the downstream state and supply all information that is available to satisfy the downstream state that no harm will be caused to the downstream state. If the harm is caused, now what to do is a separate matter. The remedies in international law are limited. In a sense, there is no compulsory adjudication where you can go and file a complaint unless there is some treaty. The remedy could be diplomatic engagement, or matter could be taken up to the Security Council. That is a separate issue on which how to address the injury. But broadly, this is the international law that it is the rule of equitable apportionment which governs, which has evolved four principles. One is each state has an equitable share. Number two, no state should conduct in a manner which will cause a harm to the other state. Three, all are obliged to protect the environment. Fourth, all states, whenever they take up the project, or the riparian state, whenever it takes up the project, particularly the upstream state, it must conduct transboundary impact assessment. This applies to downstream also, because sometimes the downstream state project might create a question of submergence or backwater effect into the upstream state. Therefore, all the states, when they take up the project, they must have the transboundary impact assessment report. This is broadly the law of international water law, you can say.
You know, a few weeks ago, we had a discussion about the Indus Water Treaty and the issue between India and Pakistan. And now we are talking about this particular issue where China and India are involved. Can we say that India is upstream in one and a downstream in another? And, you know, is there any kind of comparison that one can make? I mean,
this kind of a water dilemma in the international water diplomacy, it is called, is faced by several nations, wherein in one important river or upstream state, you speak little differently, and in another river, you are a downstream state, and where you speak from the point of the concerns of a downstream state. But broadly, the rule is equitable apportionment, as I said. But while applying the equitable apportionment, naturally, there are various considerations. Which considerations, what is favorable to the downstream state, India will apply when it is a downstream state. What is favorable to the upstream state, it will apply when it is an upstream state. So that is how it is done. It has happened not only for India, it has happened for Germany, it has happened for United States of America, and it has happened for China also, because China is also a downstream state in respect of the river Amur coming from Russia, where it has substantial stakes. So it has to be also careful in not advocating the doctrine of Harman theory that all water belongs to me. It has to advocate the principle of equitable apportionment. I'm sure it will be advocating. That is how broadly the customary rule of international law is.
So coming back to this issue about China's construction, does India have a recourse to any international body in case it feels aggrieved by let's say a shortage of the river water from henceforth once the dam is constructed?
See, firstly, India and China both are not a signatory to the UN Convention on Non-Navigational Uses of Waters. Right? It is a codification of the international water law, but it doesn't matter. Customary rules of international law apply. Now, what is the remedy if one state feels the other state is acting wrongfully? Now, in this case, if India decides to move against China on its assessment that it will cause an injury or a harm to its interest, the remedy is to move to the Security Council, raise an issue, or engage with China diplomatically and bring the pressure on China, both the regional level and international level, convince the world that the dam which China is planning, which is one of the biggest dam in the world going to be, because it is planned for storage of about 120 BCM of water, huge storage, and 3 times more than the dam which the China has already constructed, that is called Three Gorge Dam, right? Three Gorge Dam is intended to generate about 20,000 megawatt of power, whereas here it is intended to generate about 60,000 megawatt of power. So it is almost 3 times bigger. In that case, there are certain concerns for the international community apart from India that it might lead to the tilting of the Earth axis. And already the Earth axis has been tilted by construction of various dams. But this one big dam might have an impact. And if it has an impact, what impact it will have on the other items like the biodiversity with regard to the monsoon rainfall, the wind pattern, all these things have to be studied. So the international community also has an equal interest and responsibility to address this issue of dam planned by China.
So, how is China justifying the construction of such a big dam? Considering with all this, issues.
See, it is like this. First of all, there's no clarity in India also. What are our interests? If a downstream state has no clarity as to what is its interest, the upstream state feels always emboldened to take up the project as it likes. Now, take for instance in India, the Assam Chief Minister says, we have enough water to look after ourselves. Why do we need water from China? Recently, some article also appeared, Defense Research Initiative or something, that India has enough water. Why should it bother for water from China? I'm not saying anything because there is no real data available in the public domain. The Central Water Commission has not said what Chief Minister of Assam has said. But it is necessary that India should crystallize its interest in the Brahmaputra and put them across to the China. Now, the China's point of view is different. China, like India, is also committed to the carbon neutrality. It has a large number of projects to produce to generate power. And at the moment, 68% of the power in China comes from the fossil fuels, which is contributing a lot to the carbon. So there is an obligation under the COP 29 and 30 that they must reduce it to some extent by 2030. And carbon neutrality has to be achieved by 2060. And this is for India also. So China justifies by saying, at present, my hydropower generation is only 13%, and 62% comes from the fossil fuels, which I must reduce it down to about 50%. So it is necessary to increase the hydropower generation, and this dam across Yarlung Zangbo is one of the dam which is very promising to produce huge hydropower to the extent of 60,000 megawatt or 60 gigawatt. So that is how the China justifies. It's not really that great thing as China is trying to claim, and the Chinese markets are also reacting to the proposal for construction of a dam, saying that it will reduce, it will kill the dependence on coal, etc. Maybe to some extent, but not really to that extent. The real solution in China lies in tapping the wind power. In fact, they have plans to tap wind power to the extent of 1,200 gigawatt. Whereas this is hydropower is all that they have planned is to increase it by about 75 gigawatt, which includes taking about 60 from the Brahmaputra. So the real solution is not again here. They should look to the wind power. But whatever, that is the plan of China. As far as India is concerned, India is also very keen to develop tap hydropower in Brahmaputra. So there is a question that if China taps these rivers and utilizes it for generating hydropower, of course, it will release water, but in the way it likes to release. Will it affect the hydropower stations in India? This question is also being debated in India, but these are the things which require a fuller study and a study to be placed in the public domain. Then only one can really react to what extent India can suffer and how to mitigate that injury. At the moment, in the absence of anything, we can't really say. And one more area which requires to address is weaponization of water, because there is
Yeah,
a
I
lot
was
of
about to, in fact, ask you whether that
yeah,
threat,
yeah. That
whether
is
is it a
also
real threat or whether it is imaginary, is.
weaponization of water is a real threat. There's no doubt about it. It's a different matter whether China will weaponize or not. Because once a dam is constructed near the international border, a huge dam storing 120 BCM, and if China decides to release it uh, during the period of hostility, when the war is there, and best weapon is releasing water and flooding India, in that case, the whole of our Assam will be in water. Receiving about 100 BCM of water is something terrible thing. I don't think China will ever do that kind of a inhuman act. But this is a threat which we must keep in mind. And one of the solutions to mitigate this threat is to construct our own dam, the downstream, that Upper Siang project. But that is not really a dam to absorb more than 10 BCM of water. But to some extent, it will act as a buffer between the Chinese dam and the people of Assam plain.
So, given this situation as we stand today, what would you think would be the best possible response that India can have?
See, in any international water dispute or any interstate water dispute, the best thing is to negotiate and arrive at a solution based upon true and correct hydrological data. And the deal has to be fair to both sides, no doubt about it. In this case, I think India should start engaging with China and discuss out what are the possible injury or harm it thinks it might have to face in case the dam is constructed, and try to frame rules of regulations for the dam which China has planned. Once the rules of regulations are framed, we will understand what will be the nature of release of water from China, and accordingly we can plan our utilizations, our dams operation, and etc. Secondly, we must also have an agreement with regard to the exchange of data. And in fact, more hydro gauge stations have to be installed, etc. And thirdly, for a regular and continuous interaction between both the countries, including the downstream Bangladesh, International Brahmaputra Commission should be set up, like we have got Mekong Commission, where all the states will, on a regular basis, sit and discuss and consider their proposals for the development, etc. And if there are any disputes, then they'll try to thrash them out. If not possible, they may have to submit it to the arbitration or by an agreement to the International Court of Justice or some kind of a solution, whatever they like. So it is very essential at the moment for India to engage with China and enter into a treaty which will envisage framing of rules of regulations for the proposed dam, which will envisage the data exchange, which will envisage a forum named as something like International Commission to meet regularly and consider the integrated development of the basin in China, India, and Bangladesh.
But has India, has India had these kind of discussions with China in the past? I mean, since they've already started construction, is it a little too late for India to intervene?
Nothing much is available in the public domain. Something is available that before 2010 there was some kind of a agreement protocol to exchange information and data. Beyond that, nothing is available. We also don't know what sort of letters India has written to the China. Whether it has protested or not, also we don't know. Generally, Central Water Commission and Minister of Jal Shakti have issued a statement. But if the Chief Minister of Assam is speaking something to the contrary, who is an important Chief Minister, because immediate effect of this dam is going to be on Assam. And when he says that we don't have to much worry, it makes us to think that there is no clarity with regard to the issue in India. And I request that the government of India should clarify this. And if there is no injury, that our people must know that there is no injury. Nothing wrong in telling the truth, if that is the case. But we must know about it. We today really don't know. Nobody knows actually what is the total yield. There are various figures that at up to the India-Bangladesh border, it is 600 BCM. Somebody says 500. Some study says 450. One is not clear. And what is the yield at Indo-China border is also not clear. I roughly assume that it is 100 at Indo-China border and 600 at India-Bangladesh border. But this is all general. Then what are our dependence, interest, cropping pattern, when do we need water? All these things needs to be studied fully. I'm sure there is a department to study in the Central Water Commission. Very competent people are there. But it has to be placed in the public domain and the public also must know about it.
Yeah. Thank you, Mr. Katarki. I think thank you for talking to the Federal.
Thank you.